Welcome to the course Environmental Impact Assessments. In today's lecture, we will look at the other part of land acquisition, resettlement, and livelihood. So, we'll look at the Indian Act, which is available, and what kind of right to land we have. So, we'll look at that. So, accordingly, our coverage will include that we'll look at the Indian context, where we'll look at right to property. Then we'll look at the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act of 2013. And for this, you can also refer to my other lecture, for which I have also given a link there. So, the expected learning outcomes of this particular session is that you should be able to synthesize Indian context, you need to understand what kind of right we have to property, and then also look at the key aspects of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. So, looking at Indian context, let's first look at the right to property of the Indian citizen. So, I would like to remind you that in our country, right to property is not a fundamental right, but a constitutional right under Article 300A of the Constitution. So, you need to understand that we do not have it does not qualify for fundamental right, but it's a constitutional right, and then the government has the eminent domain, the power of eminent domain. So, let us walk through the key provision of right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. You may also see the lecture on Land Acquisition Act in my lecture in Introduction to Urban Planning. Link is also provided to you, and here I would cover it in a very brief manner. The Act states to ensure in consultation with institutions of local self-government and Gram Sabha established under the Constitution, a humane, participative, informed and transparent process for land acquisition will be adopted for the purpose of industrialization, development of essential infrastructure facilities and urbanization with the least disturbance to owners of land and other affected families. So, that is what the Act states, and it would provide just and fair compensation. So, it talks about the just and fair compensation to the affected families whose land has been acquired or proposed to be acquired or are affected by such acquisition. And this Act also makes adequate provision for affected persons for their rehabilitation and resettlement, and for ensuring that their cumulative outcomes of compulsory acquisition should be that affected persons become partners in development. So, it is just not that they sacrifice in the process, but they also become the partners in the development, leading to an improvement in their post acquisition social and economic status, and for matter connected thereafter there with or incidental thereto. So, this is what I am reading from the Act, and this is what you can look at those terms, which is highlights like how it is going to do through a participative, informed and transparent process. It is targets to provide the least disturbance, and it tells to provide just and fair compensation, and then how it will take care of the rehabilitation and resettlement, and then how people would become partners in development. And looking at where does this applies, where does the Act applies. So, as per the Act, this Act is concerned with land acquisition, compensation, rehabilitation and resettlement, and especially when the government acquires land for its own use, for its own use, hold and control, including public sector undertaking and for public purpose. So, you see what we studied under eminent domain. So, you see that how government can take land for the public purpose. So, looking at the purpose of the Act, we see that purpose of the act include that it would be used for the strategic purpose related to naval, military, air force, armed forces of union, including central paramilitary forces, or any work which is vital to national security or defense of India. So any such kind of thing, the government can take the land. Then you see for the infrastructure projects, all the list of activities, if you can see, includes infrastructure like all the hospitals, it can have industrial corridors, mining activities, national investment, and manufacturing zone. So, all these would be included in the infrastructure projects. This act applies for the infrastructure projects. So, all the activities or items listed in the notification provides those lists. Those will be included here. The project involving agro processing, then the project for industrial corridor or mining activities, national investment and manufacturing zones, as per the national manufacturing policies. So, you also see project for water harvesting and water conservation, structure and sanitation project for government administration, government aided educational and research schemes or institutions, project for sports. Any infrastructure facility may be notified in this regard by the central government, and those may be included in this list. Further, the act includes project for project affected families. So, the project for housing for specific income groups, project for planned development of the improvement of village sites, project for residential purposes to poor or landless or to the persons residing in areas affected by natural calamities. So, whenever such housing projects are also created, that would be also included in the list. So, land acquisition can be applied for the following types of projects: for the public private partnership projects, also for private companies for public purpose, that would also be included. And it may also apply in cases where a private company purchases land equal to or more than such limits in rural areas or urban areas, or a private company requests the appropriate government for acquisition. So, it applies to that as well. So, the act also provides certain key definitions. So, we had looked in the previous part at some of the key definitions. We can just look at some of the extra here, which might be of which is useful for our context. So, it includes definition of scheduled areas. So, scheduled areas are defined in section 2 of the provision of Panchayats, extension to Scheduled Area Act 1996. So, it defines that what are scheduled areas, and then what it really means by that, and then it also defines farmers and small farmers, meaning cultivator or cultivator with an unirrigated land holding up to 2 hectares, or with an irrigated land holdings up to 1 hectare, but more than the holding of a marginal farmer. So, such kind of definitions are given. You can go through the list from the act. So, it defines all key concepts here, what would be applicable for the act. Further, we see that this act make provision for preparation of social impact assessment study. So, in the previous class you saw what kind of social impact and the categories of social impacts and the kind of reports which are required to be made. So, here this act also makes provision for social impact assessment study. And as per the act, the social impact assessment study will include, like it has to have assessment of whether the proposed acquisition serves the public purpose or not, and then estimation of the affected families, the number of families among them likely to be displaced. Then it also needs to look into the extent of lands, like how much land will be occupied, public and private houses and settlements and other common properties likely to be affected by the acquisition. So, that all needs to be seen here. and whether the extent of land proposed for acquisition is absolute bare minimum extent. So there are chances that when proponents ask for land, they might ask for extra land than what is really needed. So this act makes this provision that what is needed is just the minimum what they really need to acquire the land. Further, we see that it also looks into whether the land acquisition is at an alternative place has been considered or not. So, if you remember what World Bank had guided, that one has to really avoid resettlement displacement has to be avoided. So, this also looks into the social impact, looks into whether they have considered alternatives or not. Further, you see that study of social impact of project should also take care of the nature and cost of addressing them and impact of these costs on the overall cost of the project, and then the benefit of the project. So, how expensive would that be? So that all considerations have to be taken care of. And then also within that social impact, the appropriate government will be required to conduct the social impact assessment study. Further, we see that the government will be required to prepare a social impact management plan. So, they would undertake a social impact assessment, and based on that, social impact management plan also need to be required, need to. So the government has to also ensure that after undertaking social impact assessment, social impact management plan is also prepared. So social impact management plan is prepared to mitigate, to reduce the negative impact which might happen with a certain kind of rehabilitation, relocation, resettlement. Further, we see that there's also a requirement for public hearing for social impact assessments in the affected areas, and one has to ensure that the views of all the affected family members have been recorded, included in the social impact assessment report. Then also social impact assessment study is required to be published in the local language, and has to be made available to panchayats, municipalities or municipal corporations. So that has to be done here. So you can connect how at the international level what kind of suggestions are made, and at the national level how we are taking care of it through this act. So we further see that one of the key feature of this act is that it is providing safeguard for food security. So it also ensures food security. So this act specifies that no irrigated multi-crop land shall be acquired under this act. Such land may be acquired subject to the condition that it is being done under exceptional circumstances. And there are instructions if such kind of lands are taken, acquired, then what kind of compensation has to be done, what kind of rehabilitation has to be done, that all guidance has been provided. Further, we see that the Act provides instructions on preparations of rehabilitation and settlement scheme by the administrator. So, you see that rehabilitation and settlement scheme, how the administrator would prepare, that also instructions are given. So, you can reconnect with the rehabilitation and resettlement plan we talked about in the previous class. So, the collector, the administrator is required to conduct a survey and undertake census of the affected families, and it would record particulars of the land and immovable properties being acquired of each affected family. So, that has to be taken rigorously for the purpose of rehabilitation and resettlement. And administrator shall record livelihood lost. The list of public utilities and government buildings would be also be made. Details of amenities and infrastructure facilities have also to be recorded. Details of any common property resource have being acquired also needs to be recorded. So, you see the kind of loss we talked about and how this act is taking care of that. So, the draft rehabilitation and resettlement scheme shall also include time limit for implementing rehabilitation and resettlement scheme. So cutoff time, we talked about that. So it is also going to have a time limit here, and then it should also be the information should be made locally available, and it has to be widely publicized. And then public hearings also need to be conducted. So you look at the participatory part as well, how the Act takes care of. Further, it also gives you what kind of procedure has to be followed, such as there will be review of rehabilitation and resettlement scheme, and then there will be this approved rehabilitation and resettlement scheme has to be made public, and publication of the declaration and summary of the rehabilitation and resettlement has to be made. So here we see that the Act also makes specifically mentions about the award, and by when the award has to be made. Like it specifies that the award should be made within a period of 12 months from the date of publication of declaration, as per the section. And if no award is made within that period, the entire proceeding of the acquisition of land shall lapse. So there's again a timeline which is given here. So the Act also provides formula to determine the market value of the land. So earlier there was no formula given, but now it is given the formula how one calculates the value of the land which is to be acquired. So Act provide instructions on calculations to determine the amount of compensation. So there's the calculation, all the parameters which have to be considered has been provided in the Act. I will not get into the details of that. So just to broadly cover that, it takes care of the in order to determine the market value, it looks at the damage sustained by the person interested. Then it also looks at the damage sustained by the person interested for the reason of serving such land from his other land, and then also all kind of damages are taken care of, and then what is the decrease of the profit of the land, and then any other ground which may be of interest of equity, justice and beneficial to the affected family. So all those aspects have to be covered here. So another term which we see is the solatium. The collector having determined the total compensation to be paid shall to arrive at a final award impose a solatium amount, which is equivalent to 100% of the compensation amount. So again solatium is also paid in addition to the compensation. Further, we see there is a special provision for scheduled caste and scheduled tribes. So like in the previous lecture we talked about taking care of the indigenous people. So here we see that how in this Act that provision is made. So there's special provision for scheduled caste and scheduled tribe, and it is stated that as far as possible no acquisition of land shall be made in the scheduled areas. Where such acquisition does takes place, it shall be done only as a demonstrable last resort. So when they don't find any other way to do it, only in that situation it has to be done. And in case of acquisition or alienation of any land in the scheduled areas, the prior consent has to be taken from the concerned Gram Sabha or whichever body is there, like panchayats or autonomous district council. So that has to be done. So in case of project where the involuntary displacement takes place, then a detailed development plan has to be prepared. So putting out all kind of how the rights are settled, everything has to be taken care of. So these development plan would also provide the program for development of alternative fuel, fodder and non-timber forest produced resources, how that's been compensated, and then it would take care of all the compensation amount, how the families are paid, and it has to be done in the similar area. As far as possible, the resettlement should be done in some scheduled area and in a compact block. So, moving forward, we see that the Act also provides format for compensation calculation as seen in the image. So, you see that it's very clear, distinct how the calculations have to be done. So, now looking at the main features of the right to compensation, this Act of 2013. The Act defines various types of public purpose. So, it's defining what are the different kind of public purpose, and then it is also making provision for the prior consent in this case, and then it is also proposes to make payment of compensation that are up to 4 times the market value in rural areas and twice the market value in the urban areas. And we also see that this is the first law that links Land Acquisition Act, and it's just not acquiring the land, but it's also linked with obligation of resettlement and rehabilitation. So, it brings the two together, and it also makes provision for retrospective operation. That means in order to address historical injustice, the bill applies retrospectively to cases where no land acquisition award has been made. So, it also facilitates that, and then it also makes provision for return of the unutilized land. So, if the land is after acquisition is not utilized, then the land has to be returned to the users, the owners. And then it also makes provision for share in the sale of the acquired land if land increased price. So, that has to be taken care of, and then also looks at income tax exemption. All amount accumulating under this Act have been exempted from income tax and stamp duty. So, we had seen that it has a strict restriction on the multi-crop acquisition, then also acquisition only if it is necessary. So, all those kind of then you see that it also provides share in the developed land, like in case the land is acquired for urbanization purpose, the 20% of the developed land will be reserved and offered to these farmers in proportion to the area of their land acquired. And then we also see that they have fishing rights in case of irrigation or hydel projects. Affected families may be allowed fishing rights in the reservoirs. And then it also makes provision for time-bound social impact assessment, and then the bill mandates a social impact assessment of every project which must be completed within a period of 6 months. So, it also ensures that the social impact assessment is undertaken. An appraisal of social impact assessment report has to be done by an expert group. So, we will be learning about social impact assessment separately as well. So, these were the key features of this Act. So, summarizing what we learned from this particular section, we learned about the Indian context, and then prior to that we had seen different concepts. We had seen the international institutions guidance, what kind of guidance they are giving, and what is the general pattern at the global level. Then we looked at what are the key documents which are required to be prepared, and what are the issues and concerns of social impact in this particular land acquisition and rehabilitation resettlement. So, today in this session we saw about this Act and how this Act takes care of all those provisions. So, we saw that how those are being translated through the legislation aspect. So, that was all for today. These were the references which were used for this particular session. These are the suggested watch and read for this segment. And please feel free to ask questions, let us know about any concerns you have. Do share your opinions, experiences and suggestions. Looking forward to interacting and co-learning with you while exploring AIA. Thank you.